Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner at Loper Immigration in our San Diego office. And I'm here as usual with the co-managing partner of WR Immigration's Boston office, Miki Matrician. Good to see you again today, Miki.
Hi, Kim. Good to see you.
So today, for our discussion with Rapid Fire Wednesday, we thought we would talk about some recent U.S. Supreme Court decisions that will have an impact on the immigration process, both family-based and employment-based. So we wanted to kick it off with updates for the beginning of the year. So Miki, for our first U.S. Supreme Court case, can you give us a little bit of an update on the Bouarfa case, if I'm pronouncing that correctly?
Yes. Yeah, so in December, the U.S. Supreme Court issued a decision on the Bouarfa versus Mayorkas case. And what happened there was that the court held unanimously that federal courts cannot review visa revocations, which falls under the discretion of the U.S. Department of Homeland Security. And basically, the situation is this, that if the immigration statute requires USCIS to approve or deny a case when some criteria are met, then if the case is denied, that USCIS denial can be challenged in federal district court. But if the statute provides for USCIS discretion in approving or denying a case instead of requiring it, then a USCIS denial cannot be challenged in federal court. And so for immigrant visa petitions, the statute says that USCIS shall, so it must approve the immigrant visa petition if the facts in the petition are true. And then if an I-130 immigrant visa petition denial can be challenged in federal court. In this particular case, the question was about whether USCIS's revocation of the petition after the case was approved, can that revocation be challenged in federal court? And the U.S. Supreme Court basically concluded that a revocation is discretionary on the USCIS by looking at the statute language, and so it cannot be challenged in federal court.
Right, that's really technical. So the order confirms the finality of the Department of Homeland Security's discretion in immigration matters, right? And then it holds their authority to revoke visas without court oversight. So this potentially leaves a situation in which the DHS revocation of the visa petition is the final decision, and then the only potential remedy being be to refile the same type of application or petition and address those issues that resulted in the revocation of the visa petition if those reasons are known, right? Because sometimes we're kind of left guessing if they're known. So the case in context at the U.S. Supreme Court, Nikki, was a family-based green card case. So can it be utilized for employment-based cases going forward?
Yeah, I think so. So, it was in the context of immigrant visa petition, whether family-based or employment-based, I think the principles will still stand. And if the employer's immigrant visa petition for an employee is denied, that denial can be challenged in court. But if the case is approved and USCIS later denies, let's say the I-45 adjustment of status application, and then revokes the immigrant visa petition, the underlying petition, after it had been approved, that won't be able to be challenged in federal court. And that can have dire consequences, right? I mean, it could leave the employee without the ability to remain in the U.S. and continue working. And that employee may be forced to leave the United States and leave the employer without the staff that they require.
Yeah, that could be harsh, especially with green card cases taking a long time and many, many years to go through. So that's a big implication. But there was another Supreme Court case that had dealt with different areas of law, not just immigration. And so, Miki, can you discuss that case? It's known as the Loper Bright case.
Yep. And that decision came down a little earlier in 2024, I think around the summer. And as you say, that case had nothing to do with immigration, but it has broad impact in a lot of different areas that are regulated by federal government agencies. What it did was it basically overturned the Chevron case that was originally decided in 1984. And by way of context, under Chevron, courts were essentially had to defer to federal agencies' reasonable interpretation of statutes. And the idea there was that federal agencies have expertise in their respective areas that judges don't have. For example, take technical and scientific fields, right? So, for example, if the EPA, the expert on the environment, and judges are not experts, and so they had to defer to the EPA if there was an ambiguity in the law. Now that Chevron has been overturned under the Loper Bright case, the Supreme Court essentially put the power back into the courts rather than the federal agencies. So essentially, this case is about deregulation.
Yeah. Okay. So, how this case will impact immigration is kind of a mixed bag, right? So, Mickey, can you talk about the impact to immigration, how it can be positive, especially for employment based immigration as we see moving forward?
Yeah. So, if an employer is seeking an approval, for example, on an H-1B visa petition for an employee, Loper Bright could make it more favorable for immigrants and their sponsors to fight it out in court if a case is denied. So, under the Trump administration, we're expecting that there will be restrictive anti-immigrant policies, and the Loper Bright case could be a helpful tool because courts would not give deference to DHS in anti immigrant rules and policies. It'll be fought out and hashed out in the courts. And then, aside from employment based immigration, Loper Bright could be helpful in cases and removal proceedings as well. In his concurring opinion, Justice Gorsuch raised the impact on immigration specifically and said that the Board of Immigration Appeals, which has issued many, many decisions that negatively impact immigrants' rights and have infringed upon immigrants' due process rights. Basically, the federal courts could undo negative BIA decisions now that Chevron is dead.
Okay. So, that's a little bit of good news from that perspective, especially coming in with the unknown of a Trump administration and how those policies may impact both family based and employment based cases. On the flip side, for people who are beneficiaries of programs created not by statute, but created by Department of Homeland Security, like DACA, which is Deferred Action for Childhood Arrivals, or parole programs, they could lose out based on Loper Bright if anti immigrant plaintiffs challenge the validity of the programs. And this is something that is a bit of an unknown right now, right before Trump administration takes place, and we're anticipating some of this action to take place. So, as you said, some of this is going to be played out in the courts, but there are also programs like the H-4 Employment Authorization Document, which we call H-4 EADs. There's also the STEM OPT extensions for F1 students that were created by agency regulation instead of by statute, and they could be vulnerable to lawsuits, as we've seen in the past. Specifically, the H-4 EAD program has been under litigation. And then in 2024, the DC Circuit Court upheld the program, which we were all thankful for. It helped a lot of employers and a lot of employees. And so hopefully it doesn't come under attack again. But changes with these programs could impact global mobility and other immigration programs if work authorization for these employees is disrupted by lawsuits and court decisions. So, we have yet to see how that's going to play out. And, as you mentioned, and I'll reiterate, people are probably going to battle it out in courts. And what is also concerning is the potential increase in the volume of lawsuits, right? Justice Ketanji Brown Jackson wrote in her dissent in a different case that there could be a tsunami of lawsuits against agencies. And I guess that could be a good or a bad thing. The potential good could be that Department of Homeland Security might be more willing to settle to dispose of more cases more quickly. And we kind of saw that during the first Trump administration, where us employment based immigration attorneys were suing more than we had ever had in the past. And that was because primarily a lot of our corporate immigration clients were ready to seek action in the courts because of what we were seeing at USCIS. Those are a couple of Supreme Court decisions that we're going to watch and see how they have an impact on immigration. And I'll say that that's a wrap for our Rapid Fire Wednesday and how immigration can be changed by a new administration. So stay tuned for future episodes on updates to the immigration landscape. And if you don't already do so, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles. And we also transcribe this Rapid Fire Wednesday into a newsletter that we release every week. So please subscribe and stay tuned. And we'll have more updates as we dig into the Trump administration coming up shortly. Good to see you, Miki. Have a good one.
Thanks, Kim.